So that also kind of creates a new space in this landscape. So with new arbitration law, we have some laws on mediation. Some of the laws are talking about mandatory mediation, a very rich jurisprudence that you've heard from Justice Jawad. So I think we're heading in the right direction, but the reason why we're heading in this direction is because of the cases and the sluggishness that we have in the courts. We have a very limited number of judges. I think we need to have far more judges. If we were to look at international parameters of having 90 judges per million, we have 13 per million. So that would mean that we would probably require about 15 to 20,000 judges. So that's another area altogether. So the mindset, the request here is that we must change our mindset. You do not go to court if you have a problem, if you have a dispute. You try to negotiate, you try to mediate, you try to arbitrate, and if nothing works, so God forbid, nothing works, or if a matter requires some judicial interpretation, do you go to court, but you don't go to court otherwise. So let's just keep courts really at a distance. And whenever you look at a dispute, and last time I spoke about the fact that the companies must think of resolving their matters within the company first. Look at their problems within their own inbuilt ADR system, and I think IBA is kind of working with companies on that account also to develop their own ADR system. If that doesn't work, and I was just talking to the Secretary General of OIC Arbitration Center, and he said, he added to this equation, and he said, let the companies first resolve it, and if the companies can't resolve it, then it goes to a sectoral ADR center which deals with that sector. For example, if it's a sugar company, then it goes to a sugar sector ADR center because they understand the problem, they understand their sector. So you do that, and then it comes out into the market, into a private ADR center, leading to a court if need be. So I think that kind of a trajectory, that kind of those steps need to be built, and I think we're just very close to that with the support of IB and others. We're heading in that direction. That is just the correct way of doing it. The other point that I wanted to make is that in a system which has judicial congestion and which has a very sluggish litigational landscape, I think it is the right to access to justice, which is a fundamental right. Right to access to justice necessitates that there have to be other routes to resolving your disputes. So when we say, it's traditionally said that right to life includes right to access to justice. Now, access to justice does not mean going to court alone. So I think it is about time that we start considering that access to justice actually means access to resolution of the dispute, a forum where I can resolve my disputes. So where there is such huge congestion, it is now an obligation on the state to provide these avenues, including mediation, including arbitration. So when I say I have a right to access to justice, it includes mediation, it includes arbitration, and it does not, the traditional notion of having right to access to justice is going to court, I think needs rethink. We need to include this into it. Secondly, I would also request that while we sort of refashioning our mindsets, we must think of ADR will stand for alternative dispute resolution. For a minute we sometimes think it's a separate little system on the side. These are the courts and then there is ADR, and should we go to that side? I think that also requires a little rethink. I think ADR or all these other avenues are complementing the justice system. They're part and parcel of the justice system. So to think that ADR is yet some other entity outside the justice system would be wrong. The justice system provides multiple avenues to decide your disputes, one being the court, but there are other avenues also. They're part and parcel of one big justice system. And if you were to think like that, that makes things far more clear, rather than thinking that ADR is some separate entity that we go to as if we just leaving the justice system and going somewhere else. That's not how it is. It's one big justice system which includes mediation as an option to resolve dispute, because justice system is nothing but service delivery of dispute settlement. So dispute settlement, one way is to do mediation, arbitration, and then also the courts if need be. So do not think of the courts to be the only mechanism as a justice justice system and this being some sort of a contraption or on the side. No, it's not. It's just one big part and parcel, and we've been now talking about it jurisprudentially also, that it's one big justice system and everything complements each other. So my request would be that we must change our mindset and start looking at taking our disputes to mediation and arbitration rather than rushing to the courts, and the courts should come at the end. And I just want to quote this Sandra O'Connor's, who was from the Supreme Court, was at the Supreme Court of the United States, and she said going to courts should be the last recourse if there is nothing else left. I think that is the mindset change that we require, because everybody, just rushes to court. Stay order le lo, ye kar lo, wo kar lo. That's not how economies run. That's not how countries run. Because if you were to look at today, if you were to examine the litigational, culture today, it is nothing but bails and stay orders. I don't know. There are lawyers sitting here. Very rare would you see a main case getting decided, because there's so many cases. There's so much rush in the courts that they're just doing, quite, work like bails and stay orders. So a country or a nation can't progress on the basis of stay orders and, bails. We need to substantively decide. One other point that I wanted to make, which gives mediation a great philosophical value also compared to, in litigation, you might lose out on a relationship. You might sever a relationship in litigation, because litigation could have any sort of results that. But in mediation, you keep your relationships, and that's what I wanted to add. That we must think of a communal relationship must always stay and should not go away. You also realize that litigation has its own pitfalls. Lawyers are sitting here, and you understand that adjournments, strikes, very frankly, we talk about this amongst ourselves, that these are very chronic problems with litigation. So fixing litigation would be a big challenge, and maybe it is done at some stage, but it is very important to bring in this new system of ADR into the mainstream and think of it as a mainstream system. So that's all I wanted to say. I'm so happy that Dr. Abdul Fareed and his team is here with the Malaysian International Mediation Center. I invite them to come to Islamabad, visit the Supreme Court this time or next time, and also visit our Federal Judicial Academy, build linkages with that also. We look forward to working with you. I'm so happy that IBA has already reached out to you and you're training people. Training is certainly a very essential component of this, because we've trained a number of judges in Pakistan earlier, and we are, inshallah, going for our first pilot ADR center, court annexed in Islamabad in a couple of months. And so judiciary's focus is to have a court annexed arbitration center, because we think we can easily migrate cases.
जस्टिस मंसूर अली शाह खिताब कर रहे थे। उनकी जानिब से कहा गया कि इंसाफ तक रसाई का मतलब मसले का हल समझा जाना चाहिए। 86% बर्डन डिस्ट्रिक्ट बार्स पर है। केसेस में सुस्त रवि के तनाजुर में मामलात लटक जाते हैं।